Please take your seats, everyone. Good morning. Welcome to the House Judiciary Committee 2024 regular session meeting number 10. Is that right? Wow, meeting number 10. It doesn't seem like we've met 10 times, but we have we did intend to have a fairly long agenda today. But before we get started, I want to announce that House Bill 286 will not be considered, and House Bill 569 will not be considered as well. I do want to recognize Chief Justice of our Supreme Court, who is here. Thank you for being here today. I'm sorry. Oh, yes. And does any member have a guest that they would like to recognize before we get started? Vice Chair Decker.
I want to welcome my circuit clerk, Wendy Graney, from Shelby County. Thanks for being here.
Welcome, and thank you for being here. Representative Nemus has a guest.
And my good friend and circuit clerk, David Nicholson from Jefferson County, is here as well. Thank you for being here, David.
Thank you for being here. Representative Banta.
And our awesome judge, Patricia Summey from Kenton County, is here. Thank you for coming.
Thank you for being here. So somebody's on Zoom. They need to mute themselves.
And Mr. Chairman, the best Commonwealth attorney in the state, Courtney Baxter, is also here. I just wanted to say hello to her.
Thank you for being here. And so would Mr. Secretary, would you please call the roll?
Representative Banta.
Present.
Representative Blanton.
Here.
Representative Bratcher.
Here.
Representative Bray. Representative Burke.
Here.
Representative Dietz.
Here.
Representative Doan. Representative Flannery. Here. Representative Herron.
Here.
Representative Kulkarni.
Present.
Representative Lewis.
Here.
Representative Maddox.
Here.
Representative Mosier. Here. Representative Nemus.
Here.
Representative Petrie. Representative Rawlings.
Present.
Representative Sharp.
Present.
Representative Stevenson. Representative Wilson.
I'm here.
Vice Chair Decker.
Present.
Chair Elliott.
I'm here, and we do have a quorum, so we are duly constituted to conduct business. And the first bill that we will hear is House Bill 804, an act relating to venue and declaring an emergency. Representative Patrick Flannery. Introduce yourself and proceed, sir.
Good morning. Thank you, Mr. Chairman, members of this committee. Patrick Flannery, State Representative for the 96th District. The bill I have before you today is House Bill 804. It is about transfer of venue. I'll say that again, transfer of venue. It's not an original venue piece of legislation. It sets forth on certain challenges where that venue would go. The bill before you says not in the same judicial circuit, but it would be an adjacent county. So it does limit the geographical scope, and we feel like would be compliant in light of the Supreme Court's decision, because we are not directing the clerk to do or not to do something. Be glad to take any questions.
Thank you, Mr. Chair, and thank you, sponsor. I am looking at Section 1, subsection 3, which is additional language. It says a party to an action meeting the definition in subsection 1 of Section 5. So I'll flip over there. That's anyone who's filing something against us to challenge the constitutionality of what we've done. Is that correct?
So yes, that is correct. So any challenges to the constitutionality of a statute, an executive order, administrative reg, or order of a cabinet under Chapter 12 would be covered under this bill.
May I have a follow-up?
Yes, please.
Thank you. So to continue in that subsection 3 of section 1, it says that anyone challenging the constitutionality of our statutes, the governor's executive orders, administrative regulations, or orders of any cabinet program, cabinet, or department shall have a change of venue upon application to the court. Are you reasonably constraining the power of the Franklin Circuit Court, or do you agree with me? I suppose you probably don't, that that's an unreasonable restriction on their power.
Well, as you can see, these challenges, that's existing law right now, so it's not italicized, black letter, underlined, that's already on there, and this bill is much more restrictive as compared to prior attempts because it does absolutely limit the geographical scope. I know at least one of our sister states has a very similar scheme set up. That would be Indiana. Spoken with Representative Nemus about that. He's actually, I think, licensed to practice in Indiana. So I do think it's much more restrictive because it does not allow, as under the prior legislation, really, in theory, the case could be brought in maybe Franklin County or even Pike or McCracken and be sent to the complete other end of the state. So I think this absolutely is much more restrictive in the geographical scope.
Thank you. May I comment?
Yes, please.
Thank you. So I am extremely concerned that this is another attempt of us to undermine our checks and balances. The Franklin Circuit Court has interpreted Kentucky law and legislation effectively for as long as I've been alive and longer. And I don't see the necessity, I suppose, of adding a shall and directing them to transfer to another forum without having considered things like forum nonconvenience. So it seems to me that it should be permissive. You may transfer to another jurisdiction, but to make it a shall really undermines our checks and balances. The judges here in Franklin Circuit have extensive experience understanding legislation. That's something that's not available in all of the contiguous counties. And while I would hope that they'll develop an expertise, my thought is that, as far as I'm aware, most of the circuit judges around Kentucky are very, very busy with their criminal dockets and the huge trials that they're handling. So to ask them to further develop their expertise to match what's already available here in Franklin County seems to me just to be an end run around justice. I can't support this as it is. I hope we can continue to talk about it.
Thank you, Representative Burke. Representative Herron.
Thank you. Representative, can you just give an example of a situation where this would come into play?
Sure. So if you look on page 2, it sets forth starting section 5, paragraph 1, subsection A. So if there was a party that wanted to challenge a statute that we have passed, they believe that's unconstitutional for whatever reason, and they did not want the case to be brought. If the case was brought in Franklin Circuit Court, they didn't want it brought there. They wanted it a transfer of venue because there are some situations where the original venue may have to be in Franklin Circuit Court. They could make application to the court to transfer that venue and argue that, Judge, I'm arguing, I'm trying to challenge the statute, this executive order. And at that point, that court would, consider that argument, make sure that it meets the Section 5 qualifiers, and then that case would be transferred to an adjacent county that's not in that same circuit.
Thank you.
Thank you. Does any other member have any comments or discussion? If not, we have Audrey Ernstberger, Kentucky Resources Council, who has signed up to speak against the bill. And if you would come forward, you would be recognized to do that. Thank you. Introduce yourself and proceed.
Thank you, Mr. Chairman, members of the committee, Representative Flannery. My name is Audrey Ernstberger. I'm a staff attorney and lobbyist with the Kentucky Resources Council. The Council, as many of you know, is a nonprofit Kentucky organization providing legal and technical assistance without charge to citizens and community groups on a range of environmental and energy-related issues. I am here to speak in opposition to the bill, House Bill 804, which selectively alters the venue rules for constitutional challenges to statutes, regulations, and agency orders. Section 1, subsection 1, retains the requirement that for any civil action triable to a jury in circuit court, a change of venue may be requested when it appears that, because of undue influence of an adversary or the odious nature of a case, a fair and impartial trial is not possible in that county. But Section 2, subsection 1, makes an exception for challenges to the constitutionality of laws, regulations, and agency orders, providing the automatic change of venue outside of that judicial district on request. There is absolutely no justification for a categorical and arbitrary distinction between constitutional and all other civil actions with respect to venue. The bill contains some of the same fundamental flaws as did last year's Senate Bill 126, which was squarely rejected by the Kentucky Supreme Court in the case of Ark Properties versus Cameron. House Bill 804 grants unchecked power to a litigant to remove a judge from a case under the guise of an application for a change of venue, thereby circumventing the well-established judicial recusal process. It divests a circuit court of its inherent jurisdiction and authority to decide when and if a case should be transferred to another venue. It intrudes upon the province of the judiciary in contravention of the separation of powers in our state constitution, and it allows for forum shopping by a litigant without any demonstration that a case cannot be heard in the initial forum in which it was filed. The bill will likely suffer the same fate as SB 126 for these reasons. Under current law, as amended in 2022, the venue for constitutional challenges will be in the county in which the plaintiff resides, or for non-residents, Franklin County. While before that time, under general venue rules, Franklin Circuit Court was the venue for most constitutional challenges due to where a cause of action arose and the residence of the defendant. The 2022 law changed that under the auspices of being more accommodating to the injured plaintiff. This effort would undercut that justification by subjecting the plaintiff to a relocation of their challenge on a motion by any party with no justification or basis. Section 2 of the bill contains an emergency clause that presents the justification for the bill and the purported necessity for immediate implementation, according to that section. It is to safeguard against the perception that judicial decisions or verdicts could be affected by undue influence of a party of the odium that attends a cause of action or defense, and because of that circumstance or nature of a case that a party cannot have a fair or impartial trial in a particular county. Leaving aside the fact that there is no categorical evidence, historic or current, that the trial of constitutional issues before the Franklin Circuit Court or any other circuit court has been anything other than fair and impartial, or that there has been any undue influence that would justify imposition of a separate venue change rule mandating transfer on demand without justification, the bill mandates venue be changed to be outside the judicial circuit on request without demonstration of any bias whatsoever. It singles out cases involving constitutional challenges while still requiring all other civil cases that there be a showing of undue influence, odium, or the inability to obtain a fair trial. There are two other related constitutional concerns regarding this bill. The first would be that it denies equal protection of the law to the plaintiffs, who on request by another party can be forced to pursue an action in an inconvenient forum with no showing that the court in which the action was filed cannot fairly adjudicate the challenge. And even after the Callaway decision narrowing the scope of challenges under Section 59 of the Kentucky Constitution, the bill has prohibited special legislation, selectively creating a new set of venue rules without rational basis and affecting a small number of courts and judges. For these reasons, Kentucky Resources Council requests that you reject House Bill 804. Thank you so much, committee members, and Mr. Chairman, for the opportunity to speak to you today.
Thank you very much. Representative Nemes, you're recognized.
Thank you, Mr. Chairman. I want to say that I have appeared before Franklin Circuit Court dozens of times, both with the current two judges and the previous two judges, and they're some of the finest judges we have in the state. Judge Shepard and Judge Wingate are both wonderful judges, prepared and very smart. I enjoy appearing in their courtroom. I would say that this I'm also an Indiana lawyer. This is very close to the Indiana rule. I don't think it's an imposition at all. Two more points I want to make. One point is circuit judges have statewide jurisdiction. They don't just have jurisdiction in the area in which they're elected. But I also want to say, because one of my colleagues offended me, I know the judges in Shelby. I know the judges in Henry, Owen, and Scott. And these judges, Judge Brummer and Shelby Spencer and Anderson, Judge Jerry Crosby and Henry Odom and Trimble, Leslie Knight and Owen Grant and Carol. She's the only one I don't know personally, but I've heard great things about her. And the two judges in Scott and Woodford, Jeremy Maddox and Judge Gabbert. These are some of the finest judges we have in the state. So any kind of intimation that they can't get the job done or that they're not up to the job where Franklin Circuit judges are, they're just wrong. There's no judge in this state better than Jerry Crosby. And so I take offense that you can be against this for some reasons, that's fine. But you cannot say that the circuit judges in areas that are contiguous to Franklin County aren't up to snuff, because they're some of the finest judges we have in the Commonwealth of Kentucky. And I regret that it was insinuated to the contrary. Thank you, Mr. Chairman.
Thank you, Representative Nemus. Any other discussion or comments from members of the committee? Not, I'll entertain a motion to adopt House Bill 804. There's a motion. There's a second. Mr. Secretary, please call the roll.
Representative Banta.
Yes.
Representative Blanton. Representative Bratcher.
Yes.
Representative Bray. Representative Burke.
No.
Representative Decker.
Pass.
Representative Dietz.
Yes.
Representative Doan.
Pass.
Representative Flannery.
Yes.
Representative Herron.
No.
Representative Kulkarni.
No.
Representative Lewis.
Yes.
Representative Maddox.
Yes.
Representative Mosier.
Yes.
Representative Nemus.
Yes.
Representative Petrie. Representative Rawlings.
Yes.
Representative Sharp.
Aye.
Representative Stevenson.
No.
Representative Wilson.
Yes.
Chair Elliott.
Aye. So with 12 yes votes, 4 no votes, 2 pass votes, House Bill 804 is passed and will be reported with favorable expression. Congratulations, Representative Flannery.
Thank you.
The next bill that we will consider is House Concurrent Resolution 124, which I'm the sponsor of, a concurrent resolution establishing or relating to the establishment of the Penal Code Reform Task Force. So I'll turn the meeting over to my Vice Chair.
Chairman Elliott, please introduce your guest and proceed.
Thank you. Good morning. I'm Daniel Elliott. I'm the state representative for the 54th District, and I'll allow my guest to introduce himself.
My name's Judge Chris Coron. I'm one of the circuit judges for the 8th Judicial Circuit, which is now both Warren and Edmonson counties. Prior to that, I served as Commonwealth Attorney in Warren County from 2005 until last year, and served as the Legislative Director for the Commonwealth Attorneys Association for about 15 years.
Thank you. Please proceed.
Thank you for being here, Your Honor. Ladies and gentlemen, members of the committee, Kentucky's Penal Code was established in 1974, and so the idea behind this concurrent resolution is to look at the penal code in a more close examination to potentially update it, to have a clear set of rules that are necessary, easier to understand, to eliminate redundancy, to make those rules coherent, and to relate to one another in a consistent, rational manner with clear, concise language that's accessible. And where possible, to consolidate offenses, have a comprehensive statement of rules, and grade offenses in a rational, proportional way. One example that we have come across is that, for instance, the violent felony statute, there are actually 2 of those. And so that honestly doesn't make a lot of sense. I have been contacted by members of the County Judges Association and members of the Magistrates Association, and so they have asked to be added to the list of individuals who would be part of this task force. And as you can tell, there would be members from the House, members from the Senate, the Attorney General, the Public Advocate, or their designees, and a laundry list of those who would have interest and obviously needed input in any task force that is created if it happens to get through both the House and the Senate, and then hopefully to come forward with recommendations on how to reform the penal code in a way that's conducive to a better judicial system for all of Kentucky. So I'll yield to my guest, the judge, to present. Thank you, Judge.
Thank you. I have actually been on, I think, 3 different incarnations of a penal code reform attempt. I do believe that this is something that is necessary and we need to continue to look at. The organization of our criminal penal code is as such that it does have some redundancies. It does have some issues that continue to arise. Even the organization of it needs to be revamped. The one thing I would kind of caution would be with the amount of members that are listed, I know that will make it more difficult. We've seen that come through at several times. I know we have a lot of people that have a lot of competing interests when it comes to any type of penal code revision, but I do think that there is the possibility to have these groups meet and come to some rational and more acceptable organization for our penal code. I do think the having these groups come in, but having a smaller group be the ones that come with more recommendations will be a more of effective process. So I am in support of it. I do think we need to continue to look at the penal code. It's going to continue to grow every year as we see just by the legislation that comes through, but it needs to. I remember when I first started as a prosecutor, we never had anything close to what we're dealing with from a technological standpoint. And we've had to, keep up with the times with technology expansion, methamphetamine production. Now we're dealing with fentanyl on a constant basis. All those things are going to require the penal code to continue to be updated, but I think a revamp and a reorganization of it is something we do need to significantly look at. And I'll be happy to answer any questions.
Representative Kulkarni.
Thank you. I just had a kind of a logistical question. So as you mentioned, there are a lot of different groups and individuals represented in this task force. Internally speaking, logistically, it says, they will come up with a memorandum or submit findings. How will those be arrived at? So is there some internal arbiter, or does everyone vote? How is that going to happen, given the disparate nature of these groups?
Well, and I don't know, Representative, appreciate the question. I don't know if you've served on a task force before here, but I would envision it much the same way, is that hopefully there would be a consensus of the membership and then a final report issued. Sometimes that's not possible, as we know when we serve on task forces. But, I would envision every group represented having input and then distilling that down to what had a majority of the membership in order to make those recommendations ultimately to the General Assembly.
Thank you. Just a
Judge, you may
quick
have some input
follow-up.
on that.
No,
sorry.
that's what we've seen previously. Like I said, I do think it needs to be driven by both the House and Senate Judiciary chairs, because at the end of the day, that's going to be the impetus for the start of the legislation if it is going to result in penal code reform. But I do think the stakeholders that are going to be involved, my experience has been nobody's going to be shy about bringing their opinions to the table, no matter what type of report is issued. So I think you will, at any point in time, be it multiple bills or any type of omnibus bill, you're going to hear probably the good, bad, and ugly of any type of penal code reform attempt.
Thank you.
And it is a long list, but we didn't want to leave anybody out.
Sure.
So, but I do understand the judge's point on that.
Representative Herron?
Thank you, Madam Chair, and thank you, Chairman, for bringing this bill forward. I am also someone who thinks that we need to take a look at our penal code, and have heard it from several individuals. So I think this is good. And as you all talked about the list being big, I was hoping to add a couple people to that list. I do think that the folks who are represented are good, but I'm always going to advocate for those who have been directly impacted by some of our penal code, for those individuals to have a voice on this. So I'm not sure if you're willing or open to add them to this official group, or to make sure that we are engaging those individuals. And then for you, Judge, I do have one specific question. Sure. You did talk about some of the barriers before when this was attempted. And I know that one thing that you talked about was the size of the group. Can you talk about a couple other barriers which you saw previously as we attempted to make changes?
Well, I think the main thing is anytime you attempt something, this is not an easy task, to say the least. If you look at, I've actually got a copy of the penal code from the early 70s, which is a book about this thick. And then you look at, I think this was the first year, the practitioner's green book, the penal code book that's sent to practitioners, is now 2 volumes. I think, like any task force, I think the most important thing is to go in initially and see what you can come to a consensus with. I think one of the most needed things, and probably something that could be achieved relatively easily, is just the organization of our penal code. It needs to be reorganized. There is some competing statutes that need clarification. I think if you start with that instead of jumping into the more controversial topics, that will have a good start to try and get something done. You know, as the old saying is, if you'll start with low-hanging fruit, you're going to get a lot more accomplished. What I've seen the failures of the previous attempts, if you want to call it failures, and has resulted in a minimal amount of legislation, is I think it tried to be dealt with in too broad a strokes from the get-go, and then you get into the divisiveness of the competing interests and really causes a derailment of it. So I think if we'll start with the more looking at the organization of our penal code from the start, I think that can lead to a more effective discussion of of more attempts to modernize it.
Yes, please.
Thank you for that. And I think that what you just said makes a lot of sense. And what I would like to see is that we try not to do this just in the interim. We obviously have elections this summer. We've got a lot of things that are happening this summer, and I think that getting a great product and trying to fit it in just this interim, I don't know that we would get that. So I would like to see us, to see what we can do to expand it out over, this year and next year. Thank you.
I couldn't agree more with that. The thought that you'll have 3 or 4 task force meetings and be able to generate a report is very unrealistic. If you look at the history of how our modern penal code was created, this was a multi-year process, and I would think the review and revision of it would be the same.
Thank you. Representative Stevenson?
Thank you, Madam Chair.
Representative Herring took one of my points, which is the time. I just got off of a task force, and more often than not, when we met, the question was, we don't have enough time to get that data. Let's just make a decision based on what we have, which is ineffective. So I would agree, too, that getting this done during the interim, if you're serious about reform, is not sufficient time. Then secondly, I like the idea of victims and people impacted by the code participating, because the community is the one that's affected mostly, not us. We can make the rules, but they are directly impacted by that. And then my last question is, will this cover re-entry back into the community and build some type of program for the success of re-entry?
That's a good question. I think it's possible that it could. I don't have an objection to your request or Representative Herron's request on including those who have been affected. And I also agree that maybe 3 meetings and a report is very ambitious as well in terms of some long-term solutions. So I think the answer is maybe, and oftentimes these task forces go where the members want them to go, as long as they're within the scope of or the jurisdiction of why they were organized. So, thank you.
About one more.
Okay, thank you.
Would we be able, I mean, they have to go within the scope, but also when the legislation says by December the 1st
Right.
of 2024, they must comply. So is
Well,
there any
right.
language
Well,
that we
I
could
think
use?
and not to interrupt you, I'm sorry.
But you did.
I'm sorry, you can finish your question.
Thank you. So I don't want to end up on the same pile of his other 3 task force that got nothing accomplished.
I understand. I think that if there aren't concrete conclusions that are made after 3 meetings and a report isn't generated, then I think there would be a request to extend it to another interim. I was on a task force in the interim, the Certificate of Need Task Force, and we ran into that same issue where we could not really make a lot of recommendations because we felt like we needed more data and more input. And so, but you have to start somewhere.
Yeah.
You have to start somewhere. So, and you have to have some guidelines that are not open-ended on something of this nature. So I appreciate your comments, and I think if it needs to be extended, we can do that at that time.
Can we add that language?
You know, I would have to consult with staff on that. I don't know if we can have open-ended task forces. Typically, they aren't. Typically, they aren't from my, I've been here a few years. I guess it'll be 8 years on the 15th. Who's counting? But usually there's an end to these task forces. But I understand your position.
Thank you.
Seeing no others, is there a motion to adopt HCR 124? Wilson? Anybody? Nemus? Motion is made by Representative Wilson, second by Representative Nemus. Secretary, please call the roll.
Representative Banta.
Yes.
Representative Blanton.
Aye.
Representative Bratcher.
Yes.
Representative Bray. Representative Burke.
Yes.
Representative Decker.
Yes.
Representative Dietz.
Yes.
Representative Doan. Yes. Representative Flannery.
Yes.
Representative Herron.
Yes.
Representative Kulkarni.
Yes.
Representative Lewis.
Yes.
Representative Maddox.
Yes.
Representative Mosier.
Yes.
Representative Nemus.
Yes.
Representative Petrie. Representative Rawlings.
Yes.
Representative Sharp.
Aye.
Representative Stevenson. Representative Wilson.
Yes.
Chair Elliott.
With 19 yes votes, 0 no votes, and 0 pass votes, HCR 124 is passed and will be reported with favorable expression that the same should pass. Thank you.
The next bill for consideration is House Bill 206, an act relating to the Uniform Collaborative Law Act. Representative Dietz. You may proceed and introduce yourself, and
Yes,
your guests would introduce themselves.
thank you, Mr. Chair and members of the committee. Stephanie Dietz from the 65th District.
John McGarvey, Kentucky Uniform Law Commissioner.
Ruth Jackson, a licensed attorney in the Commonwealth practicing family law.
Mr. Chair, I think I'm going to start by just briefly, before explaining House Bill 206, to talk a little bit about what we do as family law attorneys and why this is such a good bill. We don't go knocking on doors asking people to get divorced. I think that that's what some people think. We're here to help people when they get to us get on the other side. And I think a good family law attorney gives options. And we talk to them about mediation. We talk to them about counseling. It's one of the first questions I ask. If it feels like it's the right time, we also give them information about reconciliation and those types of things. So just because we may have a title as family law attorney doesn't mean we're advocating for divorce. A lot of times we're doing the opposite, but what we're there to do is to help them put a really good plan in place. So if they have children, they can co-parent later, and we help them divide their assets in a way that's beneficial, hopefully for the whole family. So I'm going to start with a little bit also about the evolution of family law in Kentucky and where I've seen it in 30 years of being a practitioner. And I know sitting behind me is one of my judges, Judge Summey, who I practiced family law in front of before we had family court. So back in the day, we had circuit court and district court, and in circuit court, we'd hear divorce and custody cases, and in district court, we'd have paternities, DVO hearings, juvenile matters. And we were lucky enough in northern Kentucky to be part of the pilot project years ago for family court. We had Judge Bramlage in Boone County, who just recently retired and I think was one of our finest family court judges that we had. So with the evolution of family court, we took all of those types of cases and we put them with one judge. So it was one court, one family. I remember one of our circuit court judges saying to me as he was leaving, "You're going to miss us." Because what would happen in circuit court is we were backed up to criminal cases. So if there was a jury trial and you'd walk in and have a 2-day divorce hearing scheduled, I remember walking in and the bailiff saying, "You're not going to be very happy," as we're toting in all of our exhibits, and then we get kicked. We get kicked 60 days or 90 days till we get back on the docket. I don't think any of us thought that would still happen with family court, but it is, because family court is bogged down with juvenile cases and DVOs, and it's still a very busy court system. So with this act that I'm going to let Ms. Jackson and my other witness will talk about a little bit is why this has been so good. We've had mediation, and that was new. When I started practicing, I remember asking the attorney that I worked for, "Hey, can I take this training? It costs $1,000. And her words were, "Why in the world would we ever pay anybody to decide cases when we have judges?" Well, now mediation is the standard, I know, in family court. They refer us before we can even get a trial date. So we've evolved. We settle a lot of matters outside of court. And I know for me, sometimes we may only have one issue that we resolve with the judge, because I think good attorneys look for ways to keep families out of court because we know that's the last place they should be. So about 25 years ago, I was sitting in a family law seminar, and Ms. Jackson was sitting next to me, and it was in Ohio, and we heard about this great process called collaborative family law. And I looked at her, and I barely knew her, and I said, "Why don't we have anything like this?" because we were addressing the interest of the parties, and we could pull in therapists, and we could pull in financial neutrals, and we could do meetings in our office, and we didn't file anything until we had an agreement. So it kept the case private for the individuals. It allowed us to be fiscally responsible with their money because we could use the same experts, whether it was a business evaluation or an appraisal. So it just made sense. So in Northern Kentucky, we created a group and been very successful for about the last 25 years. And we take training, and it's collaborative family law training, and there's advanced training. And we're the oldest group in the state. There are groups in Bowling Green, an active group in Louisville, and Lexington's group may be defunct. But also in your packet, you should have an ethics opinion that came from the Kentucky Bar Association. Because back in, I think it's 2005 is when we got that ethics opinion. We were concerned then because what we were doing was limited representation. We were being hired to represent our clients to settle the case. If it didn't settle, then we got out of the case if we were asked by the clients, and then they could hire attorneys to litigate the case. I can tell you in 25 years that I've been doing this, it's only happened a handful of times for me. Most people resolve their issues outside of court. But what this is going to do is it's going to put some parameters in place, and it's going to give us some consistency around the state with other states that have adopted this. So at this point, I will turn this over. So that's my hard sell. It's kind of what I do with my clients when they come in because I advocate for this process before I even talk about litigation to my clients because I know that this works and I know this is what's best for families. Do you want to?
Sure.
Good morning. I first began to practice law in Ohio in 1992 and then became licensed in the Commonwealth in 1995. And I'm here asking you to pass House Bill 206 because it's a natural extension of our dissolution laws in Kentucky. When I first became trained in the collaborative process in 1998, and that was in Ohio. Kentucky is a no-fault state, where Ohio was a fault state. So when I started my practice in 1996 in Kentucky, and in working with Representative Dietz, in talking with Ms. Dietz, it was apparent that the collaborative practice is a natural extension of the no-fault dissolution laws in Kentucky. It's a natural extension. The purpose of our statute in KRS 403 is to promote amicable settlement of disputes. Also, the same statute references that we are to mitigate the potential harm to spouses and children that accompany from litigation. So the collaborative process is an option available to our Kentucky residents to choose an amicable resolution. We have had a successful academy in Northern Kentucky since 2002. We were the first academy in Kentucky. And we are one of the longest organized academies in the United States. There have been approximately 22 states and also DC that have enacted a Uniform Collaborative Law Act. Kentucky should be among those. We have an unofficial group for the past 20 plus years and one of the longest in the United States. The collaborative process originally began only in 1993. So it was and that began in Minnesota. So it was 9 short years to where Kentucky informally adopted in Northern Kentucky the practice. I think it's important to codify Representative Dietz' sponsored act. Because it formally recognizes a practice that has been in place that residents have voluntarily chosen to utilize since 2002. It allows our judiciary to recognize this practice, which is extremely important because there are certain time frames that the judiciary follows, and Representative Dietz' act puts a stay on the proceeding in order for the collaborative process that residents choose for it to be followed. The act then prevents, a court from unilaterally intervening in the dissolution proceeding where there is history of judges calling people that have chosen to not utilize the court system and calling them to come into court. Residents don't want that. Again, I ask that you approve House Bill 206. Thank you.
Good morning. I'm John McGarvey. I'm one of your uniform law commissioners from Kentucky. I come to you not as a subject matter expert, but to tell you that as collaborative law became common across the country, was subject to a patchwork of statutes, court rules, that sort of thing. And in 2007, the Uniform Law Commission recognized we needed a comprehensive set of standardized statutes and rules to govern the collaborative law process. The act before you today is one of our acts. It went through the standard 1 year of study, 2 years of drafting, and then actually another year of kind of tweaking on it to get it just right. Since we offered it to the states in 2010, it has been adopted in 23 jurisdictions. 15 applied only to family law, 8 applied to general jurisdictions. I always have a show and tell. Blue on that map is where it's the law today. Green is where it's being considered. But it is an act that we are proud of, and I commend it to you.
Thank you very much.
Motion on the bill?
There's a motion by Representative Moser. There's a second, and we do have some discussion. Representative Wilson.
I just want to make sure I'm understanding this correctly. So if there's a husband and a wife getting a divorce, do you represent one of those parties?
Yes, so it's not like mediation.
Okay.
So the attorneys have to be collaboratively trained, and each party has their own attorney. The difference is we are hired for the limited purpose to settle their case outside of court.
And just a follow-up, if that's okay.
Yes, please.
So if the settlement is unsuccessful, do they need to get new attorneys, or can they keep their old attorneys?
No, they get new attorneys if it's unsuccessful. But I can, just to add on to that, in our experience and what we do in Northern Kentucky, we look at all options before we raise the red flag and say we're done. And that could mean even hiring a mediator to help us if we've reached impasse. But that's part of the training, is this is a negotiation model, and it's taking our clients through the steps through this model. So hopefully we don't reach impasse. But I mean, like I said, it's been a handful of cases, but it is kind of the glue that holds the whole thing together as well. And it takes out the posturing. If you don't do this, I'm going to file a motion. So it really takes the people back to the table to talk about what their interests are.
Representative Burke.
Thank you, Mr. Chair. I want to thank you for bringing this bill. I think that this is really important that we standardize this procedure, and to whatever extent it needs to be legitimized and formalized, that we do that. And it seems to me that this will be very helpful to Kentucky families as they contemplate what the next step in their lives look like. My question may be best directed, I don't know, perhaps to Mr. McGarvey.
Oh, no.
It's very similar to what Representative Wilson was asking about as it relates to transfer of counsel when, in the unlikely event this is unsuccessful, it does come to that point. So I am reading here in section 7 on page 8. As it relates to a collaborative lawyer who represents a party with or without a fee. So back in section 6, it says if your collaborative law fails, that the collaborative lawyer will withdraw from the representation and new counsel will handle the litigation. As someone who is practicing in this space, but in sort of a developing model, which is the sliding scale nonprofit model, we've seen low bono practices like the one I'm in around the country. So my first question is, have any of the states that adopted this practice defined legal services organization in the statute? Because to me, defining that specifically may eliminate some of the concerns I have.
Not to my knowledge, and I can tell you when we say 23 states have adopted this act, that means it was either identical or what we call substantially similar, and I'm unaware of amendments.
Okay, thank you. May I speak very briefly?
Yes, please.
Thank you. I will be a yes today, but it's my hope that we could work together to address the definition of legal services organization, because I am aware of various nonprofits around the state that are providing sliding scale or low bono representation, where the party is going to qualify for free legal services from Legal Aid Society or from a private firm based on their low income. But I want to be sure that we don't put them in a position where they need to change counsel when they really can't afford to. And with my local legal aid organization turning away 90% of eligible applicants, I know they're not going to take this up as a practice because they don't have the staffing to do that. But the nonprofits that exist in this legal services organization space may be able to. So I hope that we could work on that to make sure that access to justice is for all families and not just those who can afford private counsel. Thank you.
Thank you. Representative Flannery.
Thank you, Mr. Chairman. 2 questions, if I may. First, Representative Dietz, I enjoyed our conversation on this yesterday. This is new to me. Not many people can tell me that I'm wrong, and I actually continue to listen, so compliments to you on that. That's quite a feat. I guess my first question, it was my understanding that this is really, in some ways, I think of it as kind of pre-litigation mediation in some regards, where you try to work things out before the petition's filed. But I'm looking on page 4, it says the court may not order it. So is that just there to address any concerns that it's not forced upon people, or is the petition actually filed before the collaborative agreement starts?
Well, funny you should ask. I also have House Bill 205 that I think we're going to do for discussion only today. The purpose of 205 was because what we found in Northern Kentucky was to get that 60-day requirement moving, we had to file our petition and we had to file our response. So even though parties could be working on this for an entire year and come to an agreement, they didn't want to file yet because they wanted to keep it private. They just weren't ready to finalize it. So we would wait. So that's that 60 days. When we were filing that, we had one family court judge that would start putting us on the case management docket and start pushing us along. And sometimes you'd be on the docket where it's going to be dismissed for lack of prosecution. And he didn't care that we had signed the participation agreement. And what we do is we also file a notice that we're in this process, and we put that in the file. So that's why that provision is in there, because we don't want to be put on the case management docket. We don't want the court to set us for a hearing, and we don't want any court orders from they wouldn't have chosen this process if they wanted to be in court. And this is a voluntary process, so that's why we put that in there.
Okay, second question.
Yes, go ahead.
I'm very interested in this, I guess, collaborative approach. I could see many ways it could be beneficial. Obviously, there'd be situations where it may not be helpful to parties, but I guess, why do we need to codify this? Is there a reason that you feel like it's necessary that we have to codify it? Why can't we just continue to operate under maybe this ethics opinion and just kind of have this approach as it's currently happening?
For me, right now we have 3, maybe 4 groups practicing in Kentucky, and we all operate under our own bylaws. We're separate groups, and I think what this will do is it puts some minimum standards in place so that we know if You call me and say, let's do this collaboratively. I'll know what kind of training that you took, and we'll have a basis that we both understand. Sometimes we get calls in Ohio, and they're collaboratively trained under their group, but not members of our group. So we'll share our participation agreement, and then it's up to us whether we want to take that case with someone or not that's in a different group. So this is going to give us some minimum standards in Kentucky. I don't know, do you have an...
I think part of the reason to codify this, Representative Flannery, is more to stop the confusion among the residents of Kentucky. There are a much higher percentage of attorneys that are not collaboratively trained that will tell their client that they are doing this case collaboratively, when in fact they are not. They are only doing it cooperatively, and then they will litigate. And so there's this misnomer among residents of what the collaborative process is, and a lot of confusion. I will often get cases after the fact that the client will tell me that they did this in the collaborative process, and I look at who the attorneys were, and it was not a case. In fact, it was a judicial decision in the divorce case. So I think for me as a practitioner that has done this practice for 20 plus years, I think it's important for me to be able to explain, or for the residents of Kentucky to understand what the collaborative process is and not be misinformed when a non-collaboratively trained attorney says that they're going to do their case collaboratively when in fact that's not the case.
Representative Flannery, the very reason the Uniform Law Commission produced this act is to standardize practices in this area, both within a state and amongst the states.
Thank you, Representative Doan.
I have a question and then a comment on the bill. Would a judge still have the authority under this to reject a separation agreement if the judge believed that that was unconscionable?
Yeah.
Absolutely.
Yeah.
Right. And then, my comment on the bill, I practice family law. The last person that I want making a decision on my case is the judge. It's the parents that raise those kids. No offense to you over there, judges, but it's the parents that raise the kids. It's the people that entered into that agreement to be married to each other, to share finances, to share assets, to share everything, and they should be the ones to unwind it. So thank you for bringing this.
Thank you. Is there any other discussion? No, we have a motion and a second. Mr. Secretary, please call the roll.
Representative Banta.
Yes.
Representative Blanton.
Aye.
Representative Bratcher.
Yes.
Representative Bray. Representative Burke.
Yes.
Representative Decker.
Yes.
Representative Dietz.
Yes.
Representative Down.
Yes.
Representative Flannery.
Yes.
Representative Herron.
Yes.
Representative Kulkarni.
Yes.
Representative Lewis.
Yes.
Representative Maddox.
Yes.
Representative Mosier.
Yes.
Representative Nemus.
Yep.
Representative Petrie. Representative Rawlings.
Yes.
Representative Sharp.
Aye.
Representative Stevenson.
Yes, explain my vote, please.
Yes, you may.
Thank you. Thank you. Really, thank you. Like, after 40 years of practicing law, most of it in family law with poor people, I'm so happy that this has happened. And I'm also very, very happy that you're going to be in conversation with her, because most of the poor people that I represented couldn't afford a lawyer. And so therefore, they might not go collaborative because they know they've got one shot. So thank you for bringing this bill and for cooperating in making sure that it's available to all people, because the children are what's important.
Representative Wilson.
Yes.
Chair Elliott.
Aye. So with, get my microphone on. So with 19 yes votes, no votes, and no pass votes, House Bill 206 is passed with favorable expression. So congratulations, Representative Dietz. And as you mentioned earlier, we will have House Bill 205, an act relating to the dissolution of marriage.
Chairman
Yes.
Elliott, I am not here for the next one, but I feel like I need to make a comment on
Please
the
do.
resolution the committee adopted.
Oh, sure. please.
Professor Lawson, who drafted the original penal code in 1974, is alive, well, sharp as he ever was, and still keeps an office at the UK College of Law and should be consulted.
10-4. 10-4, thank you.
Mr. Chairman, can I record a vote now?
Yes, you may.
On
Representative Bland.
House Bill 804, I would like to record an aye vote, please.
And it's so recorded. So as I was saying, Representative Dietz, 205 will be considered for discussion only, and that's an act relating to dissolution of marriage, and you may proceed on that bill.
Yes, again, Stephanie Dietz from the 65th District. You want to introduce yourself?
Ruth Jackson, a practicing attorney in the Commonwealth of Kentucky.
So House Bill 205, what this does is when you file for divorce in Kentucky and you file your petition and then the response, there is a waiting period of 60 days if you have minor children before the court can enter the decree of dissolution. So this bill would remove that requirement. And I felt that this was important, one, because of the bill we just passed out of here, collaborative. There are people that spend maybe 2 years negotiating their case before they ever file. We also have mediation and other forms of ADR that are available to us that weren't available to us at the time that this statute was written. So I felt that it was important that we recognize the fact that not everybody goes to court. I reached out to several of our judges. I know in Northern Kentucky they're in favor of this bill. I reached out to Judge Fleming this morning, and he's in favor of the bill. So when I was whipping the bill, there's some opposition. I know that the feelings are that this is a cooling off period for people. What I have found in my practice is that if we're talking about people going to court, this really doesn't affect them. Because if you're going to file a petition and then you're going to file a response and you're going to get into court, that's all not going to happen in 60 days. What we're really talking about are people that have sat down and reached a thoughtful agreement after time and consideration, and they have signed it. So that's what this bill proposes, is that we remove the 60-day requirement.
Thank you. Just to add to what Representative Dietz just mentioned, what this bill, this 60 days bill does, when people have reached a settlement, it creates financial problems for those parties because it does not allow for their settlement to become final as a court order for those 60 days. And there's a lot of transactions, financial transactions, valuations that have taken place in that settlement agreement that can be quickly outdated because life goes on. People have to move on. A house needs to be sold, a house may need to be bought, and this 60 days frustrates those parties' settlement agreement and creates problems. As Representative Dietz already said, we have a 20 days from the filing of the petition. That summons, where you have to file the response within 20 days. And if you're going to court, the case is going to take longer than that additional 40 days from when you file that response. So this is really to help those Kentucky residents that work hard to settle their case, reach an amicable resolution, and be allowed to have those terms put into effect when that agreement is signed and made into a court order. Thank you.
Thank you very much. There is discussion. Representative Flannery.
Thank you, Representative Dietz. We also discussed this yesterday in conjunction with the collaborative agreement. I know just practicing law, talking to other lawyers, talking to judges, I believe there are a lot of mixed feelings on this. I know there's been plenty of times as a lawyer, I've got a separation agreement signed, file it with the petition, and I have to wait 60 days, and I just kind of feel like that's a waste of time. So I definitely get where you're coming from on this, but I think also sometimes as lawyers we become desensitized on how these things affect people, how that affects children. So I don't know if it's exactly a bad thing to have a 60-day cooling off period. I think that can be helpful. It's probably not helpful in the majority of cases. And so that would be my concern. I guess my suggestion ultimately on this would be that we consider, if your collaborative bill is passed, maybe changing that to allow, just do an exception to the 60-day rule, because that's obviously a situation where the parties have been thoughtful, mindful, worked it out maybe over 6, 7, 8 month period. So just a suggestion moving forward. I think that would be something I would probably be more comfortable with, and kind of tweaking the 60-day rule. But I think there are situations where this 60-day rule can be helpful. So those are my, I guess, thoughts and concerns.
Thank you. Is there any other discussion? If not, thank you, Representative Dietz, for your presentation. And if there's no other business to come before the committee, we will stand adjourned.